Hello everyone, let me introduce myself. My name is Beatrice Mauren Delicia, and in this video I will explain about the legal system in Bulgaria, which also includes criminal law in Bulgaria, private or civil law in Bulgaria, and contracts law in Bulgaria. Bulgaria is a country in Southeast Europe. Bulgaria borders 5 countries: Romania to the north or mostly along to the Danube River, Serbia and North Macedonia to the west, and Greece and Turkey to the south, with an area of 10,994 square kilometers. Bulgaria is the 16th largest country in Europe. Bulgaria's center of government and largest city is Sofia. Bulgaria is a unitary state with a parliamentary form of government. Between 1944 and 1989, the country was under a communist rule. Since 1992, the country has been a member of the Council of Europe, and since 2007 has been a member of the European Union. Bulgaria is a civil law country with unitary national justice system consisting of 4 levels of courts. There are 113 district courts that are handling small claims and petty crimes at the level of the municipalities, and then 28 provincial courts that act as a second instance jurisdiction with respect to the district courts and handle as a first instance jurisdiction more significant dispute and serious criminal offenses, and then 5 courts of appeal that act as appellate jurisdiction to the district courts, and 1 Supreme Court of Cassation with jurisdiction over civil, trade law, and criminal matters. And the last one, in parallel, there are 3 semi-autonomous systems of specialized jurisdiction. First, military. There are 5 military courts and 1 military court of appeal. Second, administrative. There are 28 administrative courts at provincial level and 1 Supreme Administrative Court. And the last one is specialized criminal, that dealing with mafia or organized crime cases. There is 1 specialized criminal court and 1 specialized criminal court of appeal. The next part that I want to explain is criminal law in Bulgaria. Criminal procedure in Bulgaria is regulated by the PPC or Penal Procedure Code, with some norms pertaining to police detention included in the Ministry of the Interior Act. According to Article 23 of the PPC, a penal procedure is initiated either by the police or the investigator, or with the first action of investigation, or by the prosecutor, when the necessary legal requirements are met, or there is a legal reason and sufficient data that an offense has been committed. The prosecutor controls and monitors the legality in the acts of the authorities conducting the pre-trial phase of the procedure. The prosecutor also has the power to conduct an investigation by himself or to transfer an investigation from the police to an investigator. The next part that I want to explain is private or civil law in Bulgaria. Civil law constitutes a significant part of every country's legal system. Civil law are a system of norms that regulate the proprietary relation existing between individuals within the society as well as the relevant immaterial relation. Civil law governs various contractual relations, proprietary relations, hereditary and family relations. Bulgaria's civil law was built on the foundation laid by the Roman legal system. The civil procedure in Bulgaria is regulated by the CPC or Civil Procedure Code. The main steps of the first instance procedure include 1. Submission of a statement of claim to the court, 2. Service of the statement of claim to the defendant, 3. Submission of a response to the statement of claim, 4. Sorting out the preliminary question. The court renders a ruling on the formal admissibility of the statement of claim and on admission of the evidence. 5. Court hearing for collecting evidence or in one or several court sessions depending on the evidence. And finally, the court renders the judgment. With respect to litigants who are unable to afford a lawyer, the judge ought to inform him or her about the right to legal aid. The judge also has to explain to the litigant the obligation with respect to the legal aid provided, as well as about the legal consequence if he or she does not abide by their obligation. The last part that I want to explain is contract law in Bulgaria. One of the first and most important and significant acts in the field of civil law is the Law of Obligation and Contracts, or LOC, of 1892. Its adoption made it possible to govern contractual relationship on the basis of fairness and the principle adopted in the legal system of developed European countries. The law on obligation and contracts contained rules governing trade and stimulated the development of economic relations between individuals in a society aspiring to economic and cultural development. Its creation was influenced by the Italian Civil Code, or Code Civil of 1865, which was in turn based on the French Civil Code, or Napoleonic Code. The first section of LOC contains provision for the sources of obligation, giving the most attention to contracts like subject, reason, action, and interpretation of contracts, the different types of commitments, ways of discharging the obligation, and others. The second section provides for the various types of contracts. 1. Contracts for the transfer of ownership, like purchase and exchange. 2. Contract for paid use of goods and labor, like property rental, loan of property, and loan for use. LOC regulates labor as voluntary and gratuitous. 3. Company contracts. 4. Other contracts like proxy, agreement, rent, insurance, deposit, surety, and guarantee. Bulgarian contract law is based on the freedom of the citizen and the right to own property, from which derive and the other fundamental principle, freedom or autonomy of contract. It is provided for in Article 9 of the LOC and consists in 1. Allowing any individual to conclude contracts if they so want. 2. Everyone is free to choose their contractual partner. 3. The parties are free to include in the contract whatever they consider appropriate, and the parties may enter into a contract in whatever form they wish. Freedom of contract is restricted by the principle that everything is allowed that is not prohibited by law.